Let's do this.
Good afternoon, everyone. My name is Marie Wood. Welcome to a webinar onboarding and managing the 21st century workforce. I'm an assistant to Freda Thomas, who's a certified business advisor and one of your presenters. So we're really happy to have you join us. Somebody already commented that they are able to hear us. If there's anyone who is having difficulty with any of that, just type into the question box and we'll try to help you out. And just have your questions ready for the end. We'll have a time when you can ask the presenters about the information that they've shared with you. So, Freda, you can go ahead and begin the introductions.
Okay, Marie, thank you for that introduction. Marie is the epitome, let me say that again, the epitome of a great hire. Marie is the kind of assistant that I have always prayed for. Whenever people have the pleasure of speaking with her or talking with her, they always tell me she's great, you're lucky. So thanks, Marie, and thanks for getting us started today.
Wow, thank you for those really great comments, Rita. It's really a pleasure working with you. You're just a great leader, and working with you, you understand my personality, and we have an understanding of each other that just really contributes to a great working partnership and atmosphere. So I appreciate you too.
Love Fest, yay! All right, good afternoon to everyone who has phoned in and logged on today. We are excited to present this webinar to you. The we, that's Marie, of course, William McNeil, I'm going to refer to him as Mac because I've got it like that, Daniel Bellizio, and of course me, Freda Thomas. We've got a ton of information about managing your staff in the 21st century. I want you to know that I've had about 5 cups of coffee today, so I am pretty pumped and ready to go. And I hope you've got your best listening ears perked up for today's session. Now, for the agenda, we've got about 27 slides and lots of details to share with you from experts on the subject of recruiting and employee development. Here's the agenda. I'll start by introducing the presenters. I'll discuss the reason we're exploring this topic today, and the reason for the discussion is because so many businesses are hiring improperly. We want to show you how to have good outcomes when you recruit. Some of you already have staff in place. So Mac is going to be talking to you about team building. We'll discuss the results of a bad hire and what to do about it. Daniel is going to talk about legal challenges associated with the entire hiring process. And Mac will introduce you to the DISC behavioral tool, and he will tell you how DISC, D as in David, I as in it, S as in Sam, C as in cat, can help you get the most out of your new hire and your existing hire. Next slide, please. We're broaching this topic because Daniel Mack and I have worked with businesses who are having some real challenges identifying and hiring proper staff. We've identified 4 areas we're going to focus on today. Number 1, hiring properly from the start, legal parameters of a hire, how to remove those things that cause an improper hire in the first place, and how to use DISC to get the most out of recruiting and retaining staff. We want you to come away from this time with us with new information and some great tools to help you identify the proper employee from the start. And as Marie said, at the end, you'll have time to ask questions. So let's get started. I have the pleasure, everyone, of having these handsome gentlemen on the call with me today. Do I have the hookup or what? Daniel Bellizio is a practicing attorney of the law firm Bellizio and Eagle. That's IGEL, although it sounds like eagle, you know, the bird. Employment agreements, intellectual property, copyright and trademarks, operating agreements, entity formation, fashion, beauty, arts. These are his firm's specialties, and that's just some of what his firm can do for you. William McNeil is retired from the military as a sergeant major. He's owner of TEC LLC, T for Tom, E for Edward, C for Cat, LLC, providing leadership training, conflict resolution, political leadership, and leadership team building camps. Mac is an authorized partner, everything DISC. DISC is a behavioral tool that can help you with staff development and so much more. D stands for dominance, I, influencer, S, steadiness, and C is conscientiousness. I'm Freda Thomas, owner Freda Thomas Consulting, providing business coaching services. I have been self-employed for over 2 decades, and in my current role, I show companies how to increase sales, attract investment capital. As well, I can help identify top talent for your organizations. If you'd like to know more about the participants, you can visit our LinkedIn profiles. According to Harvard Business Review, 80% of employee turnover is a direct result of hiring the wrong person. That's a significant figure, wouldn't you say? The Department of Labor statistics show that it costs 1/3 of a person's annual salary to replace a bad hire. That's just crazy. And expenses associated with a bad hire can be very costly. You've got the time and cost of training. You've got benefits to pay. And if an employment attorney like Daniel is retained, you've got legal expenses. So why do companies hire the wrong person? It's simple, really. They ignore their intuition. They hire based on skills and nothing else, or they hire because they are in a hurry. Last month, I want to give you a case. A not-for-profit asked me to help them because they hired a new person who walked off the job. Can you believe that? And their grants required them to have a certain number of employees in place in order to keep the grant money in place. This company admitted to rushing to hiring the person who walked off. They ignored all the warning signals. The walk-off had delayed providing them references. He was evasive when they asked him specific questions in the interview. And we just don't want these things to happen to your organization. Next slide, please. So, how to make sure that we avoid these terrible occurrences? First off, take the time to hire for skills and behavior. That's where DISC can help. You want to create a profile with descriptions of the type behavioral characteristics and the skills you want the person to have. You can use that profile to then create your job description. And if you need help creating the profile and job description, I can show you how to do that. If the person is working with customers, you'll probably want someone who is outgoing and easy to get along with. That's an influencer, an I under DISC. If you want a no-nonsense, take-charge person, that's D for David, for dominance under the DISC personality trait. Each candidate should take the DISC assessment. So when you're interviewing your candidates, you're going through your process of recruitment, take the time and offer the DISC assessment to each candidate so that you'll know beforehand whether or not they are a good fit. If that person fails to meet the criteria in terms of the profile and the descriptions you set out, the behavioral profile as well as the skills, my advice, don't hire them. Now, Matt can get you access to everything DISC and tell you how to use it. And now I'm going to turn it over to Matt.
Thank you, Freda.
You're welcome.
And have you all look over these slides here, these bullet sentences, and more than likely they probably sound familiar, whether you've used them or you've heard some clients use them. These ritualistic statements and questions are indicators probably of conflicting personalities. For instance, if your skills are lacking, then they would have some type of quantifiable evidence or proof to get rid of you, but more than likely it has to be qualified. Then it is possible for conflicting personality styles may be the problem. Next slide, please. And this is the definition. My background's in psychology and organizational psychology, so this is a typical definition of conflict. To be more specific, the understanding of your personality or others, how they view your personality, and other types of personalities. The perception will probably manifest itself in someone else is trying to get in the way of your success. That's what you perceive anyway, is someone's trying to stop you from being successful. Through understanding, you can, your better understanding of someone will perceive your communications and actions as well as understanding theirs. Next slide, please. Now, this is the DISC model, and what DISC does, my assumption right now would be that we have a lot of Ds in the room, probably DIs. So a DI probably isn't interested in all the real details of this. So simply put, the DISC looks at your behavior and makes assumption of your personality. Because you can't see personality, you can see a person's behavior. That's why DISC is the perfect model to be used in organizations. Dominance, a person that has a D-type style is more direct, strong-willed, and forceful. Influence, they're sociable, talkative, and lively. Steadiness, gentle, accommodating, and even-tempered. Conscientious, they're reserved, analytical, and logical. Now, if you just look over those items that I went over, you could probably see to where there'd be some type of conflict in the organization. A person that's dominant is probably not real concerned about someone that's reserved and analytical. They're more talkative, or they're more strong, direct will. So you can see how that might, a person might feel that they're either being ignored or their contributions to the organization is being overlooked. Next slide, please.
Matt, before we go on, question.
Sure.
So as you said, there are probably lots of D's and I's on the call, and I know most of the people who are online with us today, and you're absolutely right. there's a career coach on the phone today, and let's say she's I and she has some strong D tendencies. What type of personality traits under the DISC profile would be a good fit for her? And why is it important for her to know this if she's getting ready to hire someone?
Well, what you need to do is understand her personality type and how she's going to come across. If she's a DI, what she needs to know is she's going to come, the way other people will see her, their perception is that she'll come across as direct, strong-willed, forceful, and sociable, talkative, and lively. She's going to be more of a extrovert. So if she gets someone that's an introvert, then they may not come across, they may have problems with expressing themselves. So she'd really have to dig in and make them talk about themselves. They probably won't sell themselves as forcefully as someone as she would. So what's important for her is to know that she may come across as a lot of Ds like to separate the people from the problem. So they'll get more down and direct, and they want to see results, and they may forget, and they may actually do damage to a person's self-esteem, especially if they're a career coach. What they want to do is build their self-esteem along with their skills and their personality type. So that's what she probably, I would suggest to her that she knows about herself. And,
okay.
And
so excuse me, Matt. So the first part of the assessment would be that the employer takes the DISC assessment. Is that what you're saying?
Right. My assumption would be that she has taken it. Yes, I should have said that. Because the DISC is going to tell her a lot about herself and the other different personality types. That's exactly right. And then for the individual, they should take it because then she can actually do, and we'll talk about it later. Well, yeah, we'll talk about it later, a comparison report if she needs to. She's going to work, or a group report. But that's going to explain to them their weaknesses and how they can come across as fixing what may be a detriment to an organization and make it a strength.
Okay, great. Thanks for that explanation, Matt.
Okay. And we're on the comparison report now. What a comparison report does is a temporary team project or conflict management, maybe a stakeholder analysis, any reason that two people may be in a close proximity or working together that may be getting along or may not be getting along with each other. It's designed to help and understand, to build maybe a more effective working relationship. Information is pulled specifically from both DISC profiles. So both individuals have to have taken one of the DISC profiles, and that report will be specific in nature to those two individuals, after which a detailed analysis is given, of which is designed to complement each other's behavior. The report provides a summation of natural priorities each individual values. An example might be one type of personality may value time management and accuracy and independent planning versus another personality who's more general in nature. Spontaneity is important, and group participation. So because each individual is a compilation of all four DISC styles, each plan of action will provide a way to detail each other to where they understand each other's strengths and weaknesses to where you can communicate better with each other. And if there's an issue then with working together, it won't be because of the perception of personality. It'll be something more quantifiable that can be fixed easily.
Okay, that sounds great. So, Matt, can you give us a for instance where you helped a client use the comparison report? Where were they when they first came to you, and what were the results after they took part in this comparison?
Yeah, there was these two business partners. They were doing a startup, and they kind of knew each other, and they knew that they had each of them had their quirks, and they asked me if this could probably help them. I was doing a presentation, and I told them, yeah, I told them that it would if they're two partners and they're going to be working in close proximity. So they took the disc, and they were doing it was a consulting firm. So one was a D and one was a C, and usually what you'll find a lot of DIs that start businesses. So that the one person that was a D, they like taking risks. They were real strong-willed. And you have a C who's all analytical. So they took the report, and the feedback I got from them is that it helped them tremendously because what happened was they learned more about, they were taking some things kind of personal, the way they would talk to each other, and they learned that that's just the way God made them. So
right.
no longer personal. They just learned that that's just the way that individual is. That's their personality. And so they worked through that. This explained exactly the better ways to communicate. They also said that when one is out of the office, a client may call and have to speak to the alternate. And because he knew how the other person would kind of act or answer, it helped them with how they would handle that client until the other person got back to tie him over. So it actually helped them kind of mimic that individual as well as get along together.
So they became better team partners, right?
They did. They said that it helped their business out. They're accredited to the DISC as far as the internals of their organization. So they were.
That's excellent. Thank you for that.
Sure. And next slide, please. And here's a group report. Now, if you're going to be working more of an organization and you want to kind of see the culture of your organization, in this example, you can see that there's 4 Ds and 4 Is, 2 S's and 2 C's. Now, everything above that, the vertical or the horizontal line, is considered an extrovert, and everything below would be an introvert. So what you see is you have in this particular organization or this team, you're going to have a lot of strong-willed individuals where it may look like the people that are introvert are being pushed out. Their participation or their contributions may seem that they don't go answered or not a part of the organization. So what this may do for human resource personnel, they may be able to see what conflicts may arise. They may be able to predict what type of training. You know, there may be some type of training that they can look at and go, well, got a lot of strong-willed people. Maybe we need to have some type of conflict resolution or type training to go ahead and predict this and do it beforehand before it becomes a problem. Because
that is so awesome.
Yeah. So before the you have to also consider the atmosphere. So this becomes like a survival of the fittest, nature versus nurture type atmosphere. So a person in the environment may shape their DISC style, or it may not. Either way, an incompatible group can manifest in poor performance. It may be the turnover rate, complaints, absenteeism, or et cetera. In this example above, as you see that the introverts are in the minority, so you can, an HR person probably would figure that you get a lot of complaints, but with this particular group, they can look and say, well, I'm not going to get a lot of complaints because they're introverts. So what it may manifest itself more in poor performance or absenteeism, and they can look at those indicators and say, okay, well, this problem is rearing up, and this is why. So that's what you can use the group report for, and it's on a more broad scale.
And the reason why I think that's so powerful, I mean, it's because I know we have another employment attorney on the line. For instance, if someone is counseling, providing counsel to businesses, or one single business owner, and that person is looking to bring on a new team, just having this kind of chart and doing this kind of analysis can help to circumvent any type challenges before the group even gets together.
That's true. That's true. And if if let's say that the group is together and there's a conflict, if both of them have taken this profile, then that human resource can pull up their comparison reports and actually just hand it to them and have a mediator sit down with them and talk them through it. And more than likely, they'll be able to figure out if it's personality types, how to overcome that. So yes, both tools, the group report and the comparison report, are excellent tools for that.
That's great, Mac. Thank you so much for those details. And for everyone who's listening in, Mac is going to tell you about how to be in touch with him at the end. He'll provide his contact information as well. He has a special offer for those listening in today. He can tell you how you can get access to these reports. As you can see, they are very, very powerful. And with that, I'm going to turn it over to Daniel, who will talk about, Mac, thank you so much for that. We're going to turn it over to Daniel, who will talk about the legal ramifications and hiring and onboarding staff. Daniel?
Thanks, Freda, and thanks, Mac, as well. As Freda mentioned, I'm going to discuss some legal ramifications of bringing on a new hire. In addition to a new hire, much of the information that I'm going to speak about is also going to be applicable to existing employees. So it's not just exclusive to new hires, and generally speaking, there is a lot of overlap between the two. I've included a lot of information in these slides, so unfortunately, for time constraints, I'm probably going to have to breeze over some of the points, but I do believe that the slides are going to be available for download, so certainly feel free to use them as a reference point or a checklist of sorts going forward. So,
and they will be available, Daniel. Excuse me for interrupting. We will make the presentation. Yeah.
So, there's two roles an attorney can play, sort of a proactive role and a reactive role. And waiting until after you hire someone to start handling your legal house cleaning is going to be too late. Being proactive, and as Freda said, you may not always want to set aside a legal budget, but being proactive, at least generally speaking, is a cheaper way to handle things from a legal standpoint than it is being reactive to a situation that has arisen because of some error in that, whether it be the hiring process or your general employment practices. And that really does start right at the beginning when you first hire someone, when you give them an offer letter. An offer letter, I think everyone's probably pretty familiar with them. It's just outlining the basic terms of employment, the start date, the salary, etc. With that being said, each state, I think Montana being the only exception, is considered an at-will employment state. That means that an employer has the right to hire and or fire an employee for any reason or for no reason at all. Certainly some exceptions to this rule. Civil rights issues, race, religion, these are federally protected classes, and aside from those limited circumstances, an employer actually has a lot of flexibility when it comes to personnel decisions. So what you don't want to do as an employer is unintentionally tie your hands because of a poorly worded offer letter. Again, it seems like a very simple enough document. I think a lot of employers don't think that they need legal review for it, but that's a decision that can actually come back to bite them. If language in the offer letter seems to guarantee a certain term of employment, you can actually have an employee bring in an improper termination lawsuit, or at least make some type of a claim against an employer if they ultimately let that employee go. So for instance, if an offer letter says something like the employee will receive a guaranteed annual bonus or a guaranteed year-end bonus, that can unintentionally create, well, it will create an expectation that the employee is guaranteed a term of employment of at least 1 year. And when an employer goes to terminate an employee for whatever reason that may be, they may find themselves in a sticky situation because they end up receiving a lawsuit for a breach of an employment contract for reasons unbeknownst to them because, well, there wasn't an employment contract, there was only an offer letter. But if the offer letter isn't worded properly, again, it can unintentionally create a contract. So something that seems simple can actually turn out to be something more than an employer intended, and that is why it's important to start before you even offer the employment to someone. We can skip to the next slide.
Daniel, I'm glad you covered that because that was one of the questions that I was going to ask you. Why is it important to have an offer letter? Why can't you just text the employee? But there are all of the implications that could take place, right?
And that's exactly it. And I think one of the biggest, or one of the smartest things you can do is in your offer letter, look, if you want to put something in an email as opposed to a formal letter in today's day and age, I don't think that's the end of the world. Sending it via text, I think that's cutting corners more than what's necessary. But look, it's a bit of comfort for everyone. It avoids any ambiguity. I think it probably gives comfort to an employee, especially if they're leaving a previous position, to say, hey, I know I have something in writing. It looks formal. And frankly, it's more or less a template letter that can be adjusted on a case-by-case basis by the employer. So it's not a big legal expense to have someone either look over or draft a template offer letter. And it's not something that an attorney would need to do time and time again. It's just really more of a one-shot deal. But one of the important things that you want in that offer letter is you want to reiterate that it's an at-will employment. If that's the one time where you want to be very redundant about it, actually, because you don't want there to be any confusion where there's this unintentional, quote-unquote, guarantee of employment. And that's another important reason to have it in writing. It is protective.
Good point, Daniel. Thank you.
And now, generally speaking, employees are also not given written employment contracts. Perhaps some top-level executives are, but generally speaking, the employment relationship is governed by a company's employee handbook. Employee handbook is exactly what you would think it is. It's just a compilation of the company's policies, practices, and generally their benefits. But similar to the offer letter, it is not an employment contract. And this is one of the instances where it is okay to be redundant. You should be very explicit in the offer letter that the employment relationship is at will. The handbook should state the same thing. You generally want to have an acknowledgement of receipt and review of the handbook, and on that acknowledgement, which is going to be signed by the employees, you want it to state on that document as well, the employment is at will. The more times you see it, the less likely someone can make a claim that they didn't understand that that was the employment relationship. And generally speaking, the goal of the employee handbook is to ensure that all employees are treated in a uniform and consistent manner. And the handbook is not just for the benefit of the employer, it's also for the benefit of the employees. And that's why, as it says on the slide, you really must practice what you preach. If you have an established policy, you need to abide by it in all situations, and failure to do so can land you in hot water. For instance, if you state in your employee handbook that we have a certain discipline policy that we're going to provide all employees with a disciplinary warning if they run afoul of some type of corporate rule, and you fail to give them that warning and you just go ahead and terminate them for an infraction, they can bring some type of a claim against the company for improper termination. So you really need to be careful with the wording of a handbook, and I think that's probably something that's lost on an employee, because simple words like generally or typically, those are words that can actually be the saving grace to say we generally give a warning in the event of a disciplinary infraction, but that also then gives you the flexibility to not give it if the infraction is serious enough that you think that that person is toxic to the company or for some other reason needs to be terminated immediately. And generally speaking, I'll skip through this quickly because I don't want to take up too much time on this. The handbook still, even though you're setting forth the policies and procedures, needs to be consistent with both federal, state, and local laws. You know, the employer is free to set its own policies, but it still must be compliant. And general rule of thumb, we can go to the next slide. General rule of thumb is that the employment law should set the floor. So you can always give your employees more than what the law would offer them, but you can't give them less. And I just put some examples here. FMLA, most people are familiar with that. Maternity leave is governed by the Family and Medical Leave Act. Now, what some people don't realize is that FMLA only applies to companies of 50 or more employees. But with that being said, the benefit of the FMLA protection is that when you leave work for a medical issue or to tend to a family issue like the birth of a child, you have the comfort of knowing that you can go back to your position. You don't have to worry about, you know, if I have a child, now all of a sudden I'm not going to be able to have a job anymore. But employers that are smaller than 50 people don't need to give those protections. Most of the time they do anyway. It's just good business practice, and that's an instance where you're giving more than what the law would afford, but you can never give less. And similar, New York City Sick Leave Act, New York recently passed legislation where all employees are entitled to sick leave. They can accrue it, so now employers are going to have to change their policies to, or at least in New York City, to be compliant with this new act. And that's why it's also important to work with attorneys, is these laws are regularly changing, and you need to keep on top of them, otherwise you can unintentionally run afoul of the law.
Before we go, I'm sorry, Daniel, before we go on, I want to say that we do have people on the call who are outside of New York. I know there's someone on the call from Ohio. So in that regard, what would you say to speak with their local
Yeah, generally speaking, and really from a cost-benefit analysis, the easiest thing would be to speak with someone locally. So while I'm, I generally handle things like copyright and trademark law. It's very jurisdiction or state. It's non-specific because it's governed by federal law. Employment laws, although they're pretty consistent throughout the countries, like this New York City Sick Act, there are minor nuances that are state-specific, and even more locally than that. Like, for instance, New York City, it's not even the state. So it really is best when you're putting together something like an employee manual to probably work with a local attorney, just because they're going to be more familiar with that than someone who's outside of that jurisdiction.
And one other question for you, Daniel. Can you give us a case where a business owner came to you for an employee manual? What prompted them to need your help? Was there something going on within the organization and they said, if we don't address this, put something in place, the repercussions will be what?
Yeah, I mean, usually it's twofold. Usually I think you have a handful of employers who are proactive and say, hey, I'm starting to bring on employees, or I'm starting to bring on more employees, and I want to be proactive and I want to put together a handbook. Now, those are great clients to work with because it's pretty straightforward. We work with them. You're starting generally from a template and then customizing it as based on the conversation with the employer and with your client. The other portion, and unfortunately this ends up being more of the time than less, is somebody has had a employment-related issue and they've been dinged, whether it's via an employee bringing a lawsuit against a former employer, or because they've somehow run afoul of a state or local regulation, that they then seek the help of an attorney because they don't want to screw it up a second time. So I'd like to say that there are more people who are proactive. Unfortunately, there are more that are reactive as opposed to proactive, and it's generally because they've had an issue is why they come to us.
Okay.
And just briefly before we jump to the next slide, what you see here is I say that anti-harassment policies, that where previously the employment laws generally set the floor, anti-harassment policies should set the ceiling. If somebody is engaging in harassing behavior, you don't want to not be able to get rid of them until the point where they actually break the law. You're going to want to be able to give yourself the flexibility to take, whether it's disciplinary action or to terminate the employee well in advance of them breaking the law. So that's one thing to keep in mind, where it's actually the exception to the rule of the law setting the floor. When it comes to harassment, you want the harassing, the state policy or the state statutes to be the ceiling, not the floor. Okay.
Daniel, we've got 20 minutes left, so I just want to make you aware of the time.
Okay, so, and I'm keeping track of that as well. So I'll go a bit quickly on some of these, or I'll skip to the points that I think are most important for what you guys may be interested in. Exempt versus non-exempt employees. You may have or may have not heard of these particular terms. If you're exempt from overtime pay. If you're not exempt, you're entitled to it. Now, what does that mean? It means that if somebody works more than 40 hours a week, and this is regardless of if they're on salary or not. People get confused that, well, I pay someone on salary, they're not entitled to overtime. That has nothing to do with it. It's based on their roles and responsibilities. We don't have time to get into it now, but certain administrative, executive, and professionals are generally considered exempt. Most other employees are non-exempt. And that's, again, where the employee manual, to tie it back to that, you want to be specific as to how are you keeping timekeeping records. Because unfortunately, people will misclassify an employee and not pay someone overtime when they should have been doing it. But that situation is only exacerbated when you don't have timekeeping records. The reason for that is generally what happens is someone is let go and then they go and file a complaint. They say, hey, I worked overtime and I wasn't paid for it. And maybe it's true, maybe it isn't, but if you don't have any timekeeping records, and you should keep them for all employees, because you may misclassify someone, whether, it just be an innocent oversight. If you don't have the records, there's no way to defend yourself. And some place like New York, for instance, which is pro-employee, can be a major financial liability on your hands if you have to pay back pay for overtime and the taxes associated with it. So, it's, on the one hand, it's a legal analysis to know who's exempt and who's not, but by setting the policies as to how and when employees can work overtime in your employee manual, could try to nip it in the bud a bit. Again, nothing's ever sort of a magic bullet or a cure-all, but you can really protect yourself if you have the proper policies and procedures in place. We could skip to the next one. So asset protection, I'll get into this. I'm sure most people are familiar with confidentiality agreements. Confidentiality agreement is protecting your non-public information. And it doesn't need to amount to what somebody would consider a trade secret. The formula for Coca-Cola is a trade secret. Most information that people want to protect are customer lists, for instance, especially if you're in a sales position. And to protect your competitive advantage, you need to keep that stuff confidential. And you can do that one of two ways: having these types of clauses built into an employee manual, or you can have standalone agreements. It really doesn't matter. There's no benefit to doing it either way, but it is something that you should be covering in one manner or another. Same goes true for the ownership of the work. If I'm creating stuff as an employee, it's a general rule, I'm creating that for the benefit of the employer, and he or she is the one who has the beneficial ownership of it. And again, having that in writing, it avoids any ambiguities as to what is or what isn't. And again, you can actually be broader than what the law allows. So it's just things to keep in mind. And again, I'm sorry I'm moving a bit quickly. I want to just get to cover a bit of everything to not skip slides altogether. But these documents, they're not difficult to draft, whether in an employee manual or otherwise, but they are definitely things that you want to cover, because your most important assets are generally your business secrets, your client list, your customer list, things of that nature. And to not have protection over it, you can have an employee leave, start a competitive business using the information they acquired working on your dime. So it really is something that you need to cover. And I guess we can skip to the next one. This is something that I think is becoming more and more of a hot topic just because of new technologies. And I'm sorry, I just lost my place for a second. Really what it comes down to is what can and what can't you control. Generally speaking, for the internet usage, you can control what a person does, what a person doesn't do, what they have the ability to look at or not look at on company time. Again, tying it back to the Employee Handbook, is they can say you can use this, or you can look at these sites, or you can't look at these sites. Where people get a bit confused is, what if I'm looking at my private email? Well, that's not company property. I'm looking at my private email. Well, it's not that simple, because generally you're using company computers and company servers, and you don't know how the company is actually keeping backup storage and what they can what's visible to them and what isn't. So what you may think is private may not be from an employee standpoint. And those are the types of things that employers are going to want to be very, very explicit about. If you use your private email, even if you allow it, understand that there is no expectation of privacy. And I think the law is pretty settled on this. Where the law is a little bit less settled is social media. And this is something now that it's twofold. It's one, can you restrict employees' ability to speak on social media? Well, on their personal lives, no, but you do want to restrict them from revealing corporate information on there, and that ties back to the confidentiality stuff we were just talking about in the previous slide. So, a company can restrict an employee's social media usage outside of the office, again, to a degree with regard to confidential and proprietary corporate information. They can't stop employees from all social media communications. In fact, it actually would run afoul of the National Labor and Relations Act, which allows employees to discuss the terms of employment with each other. So that is something to keep in mind. So I think a lot of employees are trying to sort of steer clear of what's going on social media, because it does put a company in the spotlight, especially if someone's speaking poorly about an employer in a relatively public forum. But like I said, you cannot prevent all public conversation. And this is also going back to why it makes sense to speak with an attorney and a local attorney. There's recent legislation passed in Rhode Island that says you cannot ask for passwords to social media, which a lot of employers have been trying to do. and you can ask employees to accept a friend request or things of that nature. So while an employer can look at social media for hiring purposes, they can't require it as a mandate that you must turn something over. That's something.
Okay, that's great. Daniel, if we could move on, because we're at 2:47.
Okay, not a problem. And the last part, and this is something that I think is important, is employees versus independent contractors. And again, you guys can, if you go on Google and do a search, you're going to get a checklist as to who's considered an employee and who's considered an independent contractor. Similar to the exempt and non-exempt analysis, it's a factually based analysis. There's no bright line rule to say this person's always an employee or this person's always an independent contractor, but I did put together a checklist that I want to run through with you guys, because there are some things that I think people get caught up on, and I think these can be helpful. So one of them is if you have employees on, well, let me just take one step back. The benefit of paying someone as a 1099 is because it's generally cheaper to the employer because they don't have to pay employment taxes. The employee always has certain withholdings that come out of their check. The employer is also paying into employment taxes. So by paying someone as an independent contractor, a quote-unquote 1099, an employer's saving money. That's the attractive portion of it. Misclassifying someone and getting dinged for it, you're going to be paying more than what you would have had you done it properly from the beginning. But I don't think people are always doing it to save money. I think sometimes there's just mistakes are made. But here are a few rules to keep in mind. If you have employees on payroll who are providing a similar service as the contractor, it's more likely that that person is going to be considered a misclassified. If you're paying them as a 1099, it's more likely that they're going to be considered, that they should have been considered an employee, and they're going to, a governmental authority, whether it's the IRS or a state tax authority, is going to say that that person was misclassified. If you're paying someone as an independent contractor, generally speaking, paying a corporate entity versus an individual will lean more towards it weighing more in favor of the person being an independent contractor. Independent contractors are supposed to be in business for themselves, which means that they generally have a business set up to run their operations through, as opposed to just doing it as an individual. As I mentioned before, generally employees don't have employment contracts. It's usually governed by the offer letter and your employee handbook, but independent contractors, there usually is some type of writing setting forth the relationship between the two and what the expectations are. So again, there being a formal contract weighs in favor of somebody being an independent contractor as opposed to an employee. I think this last point that I'm going to bring up is where most people get sort of dinged on misclassifying it. If you're bringing aboard someone either as a part-time or seasonal worker, that's where a lot of people make the mistake. The intention is to bring someone on for a limited period of time. Doesn't mean that they're an independent contractor. More likely than not, they're a temporary worker, and a temporary worker is an employee, and you do have to treat them as such. You have to handle the withholdings, and that's where I think most people screw up. Hey, I only brought this person on for a couple of months or for a project perhaps. I only needed them for a short period of time, and that's where people get tripped up because they think that part-time or temporary equates to independent contractor, and it doesn't.
Okay. Well, Daniel, thank you so very much for that insightful information. And now we're going to open the floor to questions. We'd like to hear from you. If there was something you wanted us to discuss and we didn't talk about it, now's the time to share. Marie, if you would kindly tell our listeners how to go about asking questions.
Okay, so if you have a question, look into your GoToWebinar control panel and you see the blue tabs. Go down to the tab that says questions and just click on the little arrow, and there's a place where you can type in your question. And if you click send to all, then it will be visible to everyone.
No questions? Marie, is there a way to see if someone's typing?
I don't see anybody typing right now.
Okay.
If anyone has a question, they could also raise their hand, clicking on the little hand symbol. So it looks like there aren't any questions.
Okay.
Oh, okay.
So
Wait, here we go.
what you see one? Oh, I see one. Yolanda. Marie, if you would read the question for us, please.
Okay. So Linda Johnson is asking Daniel, I know you didn't have time, but what is IP ownership and work for hire?
I'm sorry, you just cut out a little bit when you said that. You said they were asking what is IP ownership and work for hire?
Yes.
Okay, so IP, my apologies for the shorthand, is short for intellectual property. Intellectual property generally relates to copyright, trademark, and patent work. So depending upon the type of industry that you're working in, an employee could be creating something that's quote-unquote creative in nature. Perhaps they're a journalist and they're working for a magazine. What writing is copyrightable. Or perhaps you work for a company that sells consumer products and you come up with a tagline or a slogan or even a brand name. That's generally protected through trademark law. And if you're working, let's say, as an industrial mechanic, you may be producing certain machinery or other type of industrial property that can be protected by a patent law. Now, work for hire is actually a doctrine that's governed by the copyright laws. So what that means is that an employer automatically under what's called the work for hire theory, and this is set forth in the copyright law, which is a federally regulated, is a federal regulation, says that anything that I create for my employer, anything that I create in the course of my employment is owned by the employer. And I do actually a lot of work with fashion, art, and entertainment. So for instance, a fashion designer, what they're creating, if they create a unique design or a unique graphic for a t-shirt, whatever it may be, that's owned by the employer. Now that's statutory. But what you want to have in, and that's what a work for hire theory is, but what you would like to see is whether, again, in a standalone agreement or in your employee handbook, is there's no reason that you can't lay that out. There's no confusion by stating it. Even if it seems obvious to some, it may not be to others, and it never hurts to avoid ambiguities. So work for hire, is something that by law the employer is entitled to it. Certain with trademark creation and or patent creation, you generally need to see assignment documents. So what you would also put in to these agreements is that everything that can be governed as a work for hire is, and the employer is the owner. And for those which wouldn't fall under a work for hire theory, you are assigning those inventions, discoveries, whatever they, however you want to sort of put your laundry list of potential intellectual properties, how you want to list them, that the employee is assigning those to the employer as a condition of their employment. So that's what that's referring to.
Okay, great. And Mary has a question. And Renee, too.
Okay, so
Marie?
Mary just asked, what do companies do now in terms of onboarding to prevent turnover, and what processes do they put in place?
Did she ask anyone in particular?
No, it looks like a general question. Maybe that's more to
Okay.
you.
I think that's probably a good question for Matt, too.
I would say probably you'd have to pinpoint where the issue was, the problem was. The way we would do that scientifically would be to make sure that everyone is taking a DISC profile, and then depending on where the issue was, you'd be able to address it directly between the individuals. It's always best to address a problem at the lowest level first, and then as it comes up. So to prevent that turnover, you'd have to find out the issue. If it's personality types, that should be an easy fix. If it's some other type of skill type, then that's when you would probably get into a more legal type term.
And Mary is our resident career coach on the call, so I'm sure she'll probably have further questions she might want to follow up and ask Matt. And what's the question for Renee? Marie, I'm having trouble opening the questioning panel, so if you don't mind.
No problem. So Renee has a question for Mac. What can I do if an employee doesn't want to take the DISC profile? I just drive a truck. I don't want to take a test. That's their mentality. And also, will we have a link or access to a DISC test?
I didn't get the last part.
She's wondering
if repeat the last part for me.
She's wondering if there's a link or some way to access a DISC personality test.
Okay. For the first part of the question, if they don't want to take one, of course you can't make them. But DISC also has something called people reading, to where you learn how to read a person's behavior and make assumptions about what DISC style they would be. So that person wouldn't benefit from being able to see what the perception is about their DISC, or how other people perceive them, but you'll be able to make perceptions about them and be able to use it just as if it was some type of person. It's just not accurate. And yes, there is a link. Once you've paid for the profile, what happens is you send a link, and then you'll click on that link. That link is good for so many days or hours, depending on the vendor, how they set it up. You'll take it, and then what'll happen is you'll get back a PDF file of your DISC profile, and it'll be about 23 pages. And if you're an individual, self-employed, there is a way that I can set it up to where it's all coming from you as if it was part of your business.
Okay, great. And since we only have a few minutes left, if we could go to the next slides, I'm going to just run through these. Thank you so much for those questions, and thank you for your responses, gentlemen. So Daniel can help anyone on the call who is looking for HR management assistance. As we said, this presentation will be made available to you. You can simply email Marie at marie.therese.wood@consultflt.com. You should have her email. I think she sent it from my email address, so maybe not. You can email her and request a copy of this presentation, but Daniel can help with drafting the offer letter, employment and independent contractor agreement, and the other items you see here. Next slide, please. And Daniel has a special offer for any listeners on the call today, a 20% off any of his HR management programs. And you can reach him at this phone number. Next slide, please. And here's Daniel's contact information, and he's located here in New York. Next, please. And William can provide you with facilitated professional development. He has several books and setting up the business enhancement through using DISC. Next slide. And these are his 2 self-published books. And you can reach William at this contact information, the phone number, his email are listed here as well. Next, please. And I can help you create a profile, your job description. We would work together to identify the skills as well as the DISC behavior that would be most eligible for your employee, the employee that you're looking to hire, or for your organization, the proper fit. I can help you as well determine whether to hire that person or not that you're potentially interviewing. Next slide. And as well, I have a special offer. Anyone who contacts me within the next 48 hours, that would be by the end of day Thursday, I'm offering 20% off my staff recruitment package. And if any of you are interested in purchasing the DISC behavior, you can contact either Mac or I. We work together in that regard. You can reach me via phone or schedule an appointment through Visita. Next, please. And with that, I would just like to say thank you, not just, But thank you to everyone who has listened in today. You certainly could have used the last hour to do something else, and we are truly grateful that you have chosen to spend this time with us. Mac, Daniel, and Marie, and I thank you very much for your support and participation. Again, this webinar has been recorded. If you'd like us to send you a copy, email Marie at marie.therese.wood@consultflt.com. This concludes our webinar. Bye, everybody. Have a great afternoon.
Thanks, everyone.